Hello and welcome. I'm Michael Worth, Vice President of Sales at Compliance HR. Thank you to everyone for taking time out of your busy day to join us for today's webinar, HR Overtime Essentials. Today we'll cover determining overtime classification, provide updates to tip credits, a refresh on calculating the regular rate, and introduce you to Navigator Overtime. For those of you who are not familiar with Compliance HR, we are a unique joint venture between an artificial intelligence platform, Lieu, and the world's largest employment law firm, Littler Mendelsohn. We have over 20 applications that provide all the different employment rules and regulations you would expect. We have applications for independent contractor. We have tools to help you create and maintain handbooks, as well as Lieu. But today we're going to focus on Navigator OT. Navigator OT is my favorite application. It thinks like an attorney. Based on this fact pattern in this jurisdiction, here's the level of risk. You know, for all of you that are on the call today, you know that it's more than just going beyond the minimum salary requirements, the duties, the importance, the authority. Those are the things that really challenge people. And you all know this because we had close to 2,000 people sign up for this webinar, and more than 3/4 of you are already attending to try to figure out how you can use these applications. Navigator OT is loaded with all the federal and state tests, and Littler attorneys also analyzed over 2,000 reported court decisions and opinion letters and built that into the logic of the application. Users answer questionnaires and receive a comprehensive risk report. It helps them understand and lower the risk. We get a summary of the federal and state rules that were in play, as well as a transcript that goes into the questionnaire. Navigator OT helps you quickly identify where your risk is so you can focus your time and money on the most important things to you. It blows my mind that there are over 92 different minimum wage rates in effect today. And how do you keep track of that? 92, and they're changing all the time. What about final pay and posters and all those other things? Keeping track of that in this day and age is almost impossible. But with our tools, we can help you quickly, in 3 to 4 clicks of the mouse, get answers to these questions, and we'll show you an example of that later on in our presentation. Don't worry if you miss something. We'll send you the slide deck. We'll send you recorded of the presentation today. But please, if you're serious about compliance, take advantage of our demonstration with me and my team. We'll show you how to use our tools, and then we'll give you a 2-week free trial. You can use the link up on your screen. You can use the URL at the footer of each one of the slides today, or you can just request it right from the Q&A. And please use the Q&A to send us your questions. We always want to hear them, and we'll try to answer as many as we can at the end. Now, let me introduce our featured speaker and my friend, Libby Henninger. Libby is a shareholder at Littler with a wide-ranging employment law practice with her primary focus on litigation, compliance, and consulting of all aspects of federal and state wage and hour law. She represents and partners with her clients across the country to strategically maintain legal compliance with ever-changing employment laws. Hello and welcome, Libby. What do you have in store for us today?
Thanks so much, Michael. I'm very happy to be here with all of you. Wanted to just briefly touch on, I know Michael gave an overview of our agenda, but today we're going to touch on 3 of, I think, the topics that I get the most questions on these days, and things that we just wanted to do a quick refresh. And I think all of these topics we could spend at least an hour on, so I'm not going to give due course to any of them. I'm sure you're going to have questions on all of them, so please, feel free to ask your questions in the chat box, and we'll be happy to try to address those or get back to you with some of those answers if we don't fully cover it on this presentation. But we wanted just to talk briefly about determining that overtime classifications. I mean, that's kind of the basis of overtime law, is whether or not your employees are exempt or not from overtime. And then I just wanted to talk about the updates. If you have employees that are subject to, or that receive tips or subject to tip credits, just some of those recent updates to tip credit laws. And then we're going to round out the presentation with probably the topic that I get the most questions on and address on almost a daily basis, and that is calculating the regular rate and what compensation needs to go into the regular rate and what is truly a discretionary bonus. Is there really a discretionary bonus or not? So let's get started with overtime exemptions. Now, just starting with the basics, as most of you on this call probably know, under federal and state law, employees are entitled to overtime unless they meet an exemption. The main exemptions that are applied are what are known as those white-collar exemptions. So I've listed them here for you. There are dozens and dozens of other exemptions that apply either to various industries or occupations, but they're not largely applied. These are the ones that we see most frequently. They're your executive exemption, which is really your supervisor exemption, the administrative exemption, your professionals, your doctors, your engineers, your lawyers, your creative professionals, your computer exemptions, and then those outside sales employees, those outside sales exemptions. And really, when you're looking at exemptions, there are three main tests that you have to meet to qualify for any exemption. First, you have to look at the salary level. Are they meeting the minimum salary level? Are they being paid with some few exceptions, which we'll touch on a salary basis? And do they have duties that meet the duties tests that are set forth on each exemption? Now, let's talk about the minimum salary level. This was updated fairly recently, went into effect January of 2020. And under federal law, you have to now pay a minimum of $684 per week. And this has to be paid on what's called a salary basis. So it's kind of the second prong of the exemption test, which is to say that it's going to have to be paid on that set or fixed amount, and it can't be subject to improper deductions. So in other words, you can't reduce that salary based on the amount of hours worked or the quality of work. Now, there's some exceptions, and we'll talk about those, to who has to be paid a salary. You don't have to pay a salary for outside sales people, for your doctors, lawyers, and teachers. And also computer professionals, computer employees can potentially be paid on an hourly basis. You would just have to pay that minimum hourly basis for all hours worked. There's also under federal law what's called the highly compensated employee test. Now, this is, I look at this more as a relaxed test, a relaxed exemption test. It kind of compresses the exemption test for those people that are making a high enough salary, which has currently set at $107,432. So it's very specific. That's in any 52-week period. There's a catch-up payment option as well. So if you're not quite going to get there, you can kind of give a lump sum at the end. But it's really looking at, it kind of substitutes one of those requirements. It will substitute in for that compensation. So basically, the more someone makes, they're looking at it and saying, okay, well, we're going to relax some of the duties test because they're making so much, but they still have to be customarily and regularly performing an exempt duty. So that meets one of those either executive, administrative, or professional exemptions, and it has to still be in office or non-manual work. So you can't have someone that's doing manual work, so maybe a field technician I've seen this come up in, for example. So someone that's doing pretty manual work that's really highly compensated would still not qualify under this exemption. Now, we talked about the last part of meeting an exemption test would be meeting the duties test. Now, we could spend the rest of this presentation just talking about those individual duties tests for each exemption, but just know that to meet each exemption, you're going to have to show that the duties of each employee meet the requirements for those exemptions. And those vary or change depending on which exemption we're looking at. So like I mentioned before, if we're looking at the executive exemption, you're going to have to show that they're directly supervising two or more people. If we're looking at the outside sales exemption, we're going to have to show that they're working outside of an office and that they're working in making or obtaining sales or contracts. So there's different requirements that attach to each of those exemptions. But with most of those exemptions, what you're really looking at when they say duties, you're often looking at the primary duty. So it's kind of a term of art that's used. And while, oftentimes it represents the duty or duties that the employee spends most of the time doing, it's not always the duty that they spend all of their time doing, or even more than 50% of their time doing. Although that is something that you would want to look at, but it's really the most important duty that they are performing. I really look at this requirement as the duty or duties that exist, that are present or exist, and that's why that position exists. So for example, it's why a manager of a store who might spend a lot of time performing non-exempt work like stocking shelves or working a cash register could still be exempt, because the most important duty she performs is that she's in charge of the store, or that she's supervising all of the employees at the store, even if she's performing a lot of the same type of work that those non-exempt employees are performing. That's really what we're meaning when we say primary duty. Now, what we just covered covers federal law, or what's covered by the Fair Labor Standards Act, which really sets the floor for what you look at when you're looking at requirements for meeting exemptions. But there are many states, about half of them, that have wage and hour laws that provide requirements that are greater than the federal law. So if you have employees that work in any of these states, you also have to make sure that you're complying with not only the federal rules that we just walked through, but also those state rules, which might provide requirements that are greater or in excess of what the federal rules provide or require. So I'm just going to kind of run through some of those key differences to kind of give you a sampling of what the differences are. So for example, these states have different minimum salary requirements for exempt employees. So we talked about those minimum salary requirements for meeting exemptions. You're going to also have to look at the minimum salary requirements that might be higher in many cases or different in many cases in these states to ensure that you're complying. Now, I spent a whole slide talking about the highly compensated employee test. If you have employees that are working in the states that are listed here, you can just ignore that slide because these states don't recognize that exemption. So even if they are making in excess of $108,000 or $107,432, you would still have to ensure that the full duties tests are met. You don't get the advantage of looking at the highly compensated test. Now, these states that we've identified, they don't have a separate computer employee exemption, meaning that there aren't it isn't recognized as a separate exemption. Now, that doesn't mean that your computer employee professionals can't still be recognized as exempt. It just wouldn't fall under a separate computer employee exemption, but they can still qualify potentially under either the administrative or learned professional exemptions. They just never adopted the updates when the computer professional exemption was added. Now, there are quite a few states that have different duties tests, and we've kind of highlighted them there. And so if you have employees in these states, you will have to just take a closer look to see if they meet both the federal duties and the state duties. And on the next slide, we've highlighted some of those key differences. So a lot of them deal with the outside sales exemptions, right? So if you have sales employees, you're going to want to really be mindful that there are a lot of key differences in a lot of different states, particularly with the time that you have to spend working outside. There's a lot of different limitations, time spent on non-sales work. All of you that have employees in California, you're already, I'm sure, well-versed and well aware of the differences in California, that although I also spent a slide talking about primary duties and that it's not always indicative of spending 50% or more of your time on a duty under the federal test. That's not the case in California. You do have to spend more than 50% of your time on those exempt duties in order to qualify. While it's hard to keep all these rules straight, I will just go back to what Michael had said kind of at the top of introducing this presentation, that there is a tool that can help, and that's Navigator OT. And Navigator OT, as he had mentioned, takes into consideration all these state tests as well as the FLSA when providing that risk assessment related to the classification of a position. So that is one option that you can utilize, because I know you're looking at all these charts with all of these differences and all this color coding. It does become a little bit unwieldy. But there are different tools out there, Navigator OT being one of them, that can help kind of drill down and takes into consideration all the state tests. I also did want to point out, when we were talking about the salary updates and how that was updated not that long ago, although it did go through some litigation and some modifications. The Obama administration had proposed increasing the salary level significantly, and then there was some litigation on that, and so ultimately it did result in that minimum salary level being increased to $684 a week, which hadn't been increased in some time, since 2004. But I did just want to point out that the Biden Department of Labor has recently indicated that it's going to be revisiting the FLSA, including what the appropriate minimum salary threshold for exemptions should be. So we actually might see some further movement in this area as well. So the issue of what the minimum salary level might not have been put to rest. We might still be seeing some proposals for some additional increases. So stay tuned there. And speaking of some recent updates to regulations, I wanted to move along to looking at some updates that went into effect late last year involving the tip credit, and speak to those who use the tip credit. So by way of background, the Fair Labor Standards Act allows certain employees who receive tips to be paid a tip credit, not using the tip credit. And what this means is that employers have to pay a minimum cash wage. And federally, this has been set at $2.13 per hour. And then the additional $5.12, which gets you to the federal minimum wage rate, can be credited in tips that the employee receives. Now, if an employee does not receive enough in tips to make or meet that credit, the employer still has to make up that difference in cash wages. Now, if an employer is going to take the tip credit, the Department of Labor and the Fair Labor Standards Act has indicated that there are certain requirements that the employer has to make sure that it's meeting. One being that it has to make sure that it's providing notice to the employees who are subject to the tip credit of the tip credit requirements, and that's a requirement in order to validly take that credit. So for many years, there's been this debate over the amount of non-tip producing work activities an employee can engage in and still take the tip credit. Because really what the tip credit is looking at, it's looking at employees who receive tips, so they're considered to be tipped employees, and then they're able to get a sub-minimum wage or get this, lower cash wage because they're making up the difference in the tips that they receive. And so there's been a lot of back and forth over, well, how much kind of non-tip producing work can they engage in and still get the benefit of getting the credit for the tips that they're receiving. So the Department of Labor had implemented what's call it the 80-20 rule. You're probably familiar if you have tipped employees. And what that means is that at least 80% of work needed to be devoted to tip-producing activities in order to take the tip credit. And only 20% of the time could be used for non-tip producing activities. And if more time was spent in non-tip producing activities, then the tip credit couldn't be used, or you would risk losing the tip credit. Now, over the years, there's been a lot of back and forth, both in litigation at the court level and also with the Department of Labor on this so-called 80-20 rule and how it's going to be enforced, because it leads to a lot of uncertainty in its application, right? What's tip producing? How do you quantify it? It's really hard, particularly in restaurant settings, to really start quantifying what's tip producing, what's not, and breaking it down that way. But the Department of Labor under the Biden administration last year did publish a rule that went into effect in December, which restores that 80-20 rule and breaks work down into 3 categories. And so the way the Department of Labor has broken work down and defined it is that there's tip-producing work. So when you're directly doing work that is resulting in a tip. So let's think of I'm just going to use a restaurant setting because it's probably the easiest to talk about. But if you're waiting on a customer, that is a tip-producing work. Then the second category is directly supporting work, which is work that supports that tip-producing work. So it could be filling salt shakers or cleaning tables, or things that are not directly supporting the tip, are not tip producing because you're not customer facing at the time, but it's directly supporting that tip work. And then there's a third category, which is not part of the tipped occupation. So it would be cleaning the bathroom, for example, or if you're you're working in 2 roles, maybe you work at the back of the house and you are a dishwasher for part of the time. Like, that's not a tipped occupation, and so that would fall into that category 3. And the Department of Labor said that any time in category 3 has to be paid at minimum wage. But how are they treating 1 and 2? So under the tip credit rules, they have said that number 2, which is the directly supporting duties, can still be paid at that tip credit with the following limitations. It cannot take more than 30 continuous minutes. So think of, rolling silverware or cleaning tables or pre-shift meetings or things like that. You can do that and still take the tip credit, but you cannot do it for more than 30 continuous minutes. Or you cannot do it for more than 20% of the total hours in a work week for which the employer has taken a tip credit. So that's where that kind of 20% rule comes into play. So you can't do it for 30 minutes or more at a time. So it has to be kind of broken down. And then in total, when you're looking at your total work week, if someone works for 30 hours in a week, they can't spend more than 6 hours performing this directly supporting work. And this includes idle time. So it includes time spent if you're working and it's slow and you're waiting for a new table to come or something like that. It it includes time spent any time before or after the business opens, because the Department of Labor indicates that you can't be performing tip producing work during this time because the business isn't open. And then, of course, as we've talked about, it's that side work and the prep work are all subject to those limitations. So that's all considered, or it's all considered to be in that second category, which would be directly supporting those tipped duties. And so really, if you are taking a tip credit, meaning you are paying less than minimum wage, and you are taking some sort of credit to get yourself up to the federal minimum wage, you need to make sure that you are looking at these rules and making sure that employees are not, are not going over these limitations pursuant to these new rules. The one thing I will point out is that you can pay minimum wage, and then so long as you're paying minimum wage per hours worked, the 80-20 rule would not apply. It's only when you're taking the tip credit. And I want to talk a little about tip pools, because I get asked a lot about tip pools. Particularly I think in the pandemic, we've seen a lot more tips just popping up in a lot more places. And so how can those tips be distributed? Again, so long as if you are not taking a tip credit, you can distribute them any way you want. So if you are paying people minimum wage, you can distribute them any way you want. But if you are taking the tip credit, they are subject to certain rules. So the tips generally have to be retained by the employee, and they generally are limited to employees that receive tips, so those tipped employees. And generally you'd have to divide it out between front of the house and back of the house. So people that don't typically are not tipped employees, such as dishwashers, janitors, chefs, with some exceptions, but typically, those are not tipped employees. And they can be mandatory if you want for your tipped employees, and there's no caps on contributions to employees, but you do have to inform them of those tip pool requirements. Now, as I mentioned, there was an amendment, and this was an amendment to the FLSA, but it does permit tip pools to be widely distributed if you are not taking the tip credit. Now, the only limitation to that, so if you don't take the tip credit, you're paying people at least minimum wage or above, and employees are receiving tips, you can pool it. You can pool it with back of the house. You can pool it with hosts. You could pool it with anyone you would want, except you cannot pool with supervisors, managers, or owners. So anyone that is supervising, managing, or owning is considered, management, or the house cannot be included in a tip pool. I've mentioned a couple of times, but it's worth another mention about the notice requirements, because they are important, and a lot of states have very specific notice requirements as well that you'd want to take account of. Sorry, I'm not advancing my slides as quickly as I'd like. You just want to make sure that you are providing notice to your employees about the cash wage that you're going to pay them, the amount that you're going to take as a tip credit, any type of tip pool that you are going to engage in, and that the tip credit cannot exceed actual tips received. So you can't take more of a credit than what's received, and that all tips received by the employee have to be retained unless if there is that valid tip pool. Now, I will note one correction on here, but I did want to just highlight state law that there are 7 states in which the tip credit is not allowed. And there are actually 27 states plus the District of Columbia. So this is inaccurate. We will update this and recirculate this. New Jersey should also be on here, but that require a higher cash wage than the $2.13 per hour. And there are some states that do not allow mandatory tip pooling. And I will say that there are many states out there, several states, including and then also the federal government, that have made proposals to try to eliminate the tip credit altogether. There are some states, including the District of Columbia, that have had, that have taken steps and might eliminate the tip credit altogether in the upcoming years. And I know federally there have been several initiatives that have tried to, and with no success so far, but we'll have to see, might have success in the future with undoing the tip credit altogether.
Libby, tip credit sounds pretty easy, but when I look at that last slide, it actually looks quite busy. And we had a build-out slide here, which isn't working based on how our presentation or webinar is going on. But I wanted to show you an example of how you would be able to get that information right by using our pay practice tools. And if the build-out was here, you would see a map of the United States. You would click on the state you were interested in. Let's say it was Washington. You would answer a question, are you interested in tip credits? And you would say yes or no. Based upon doing that, it would ask you, what city are you in? Are you in Seattle? And then when you answer those questions, and it's literally 4 clicks of the mouse, it tells you the minimum wage in Seattle. It breaks down the tip credits. They are prohibited in Seattle. And then it gives you insight. And that's what this is, the last slide that you would see at the very end. It breaks out the minimum wage, it tells you the tax credit, and then it also tells you when you can expect change based on your size and your industry. So this is just one example of the Navigator pay practices, where you simply click on the topic, whether it's travel time, final pay, or tip credits, and literally within a few clicks of the mouse, you get accurate and up-to-date information. Our feeling is that people start with accurate and up-to-date information, they're less likely to get in trouble in the future. And please, if you haven't signed up for our free trial, you can either ask for it right in the Q&A, and we'll be happy to sign you up. You can go out to our website at compliancehr.com and request a demo, and we'll get you all set up. And Libby, I'll pass it back to you.
Great. So I wanted to move on to our last topic, and I wanted to briefly walk through one of the areas where I get probably the most questions, and that's how to calculate the regular rate of pay. I wanted to start with the general concept of what the regular rate of pay is. The regular rate is all remuneration paid to an employee in a work week divided by all hours worked in the work week. I know those are kind of big concepts, but basically it's all compensation that an employee gets paid in a work week, and then you divide that by all hours that they've worked, and then you get the rate, and that's the rate in which they should be paid overtime. Now, I will make a note for all of you that have California employees that there is a difference if you have a flat sum bonus where you divide the bonus by straight time hours only. So to get the regular rate, generally you're dividing by all hours worked, which includes overtime hours. So, if they worked 45 hours, you divide by 45 hours. In California, if you have compensation that would be considered a flat sum bonus, which is something that if you have questions on what a flat sum bonus is, we can absolutely get you to an expert. But it's a amount that is kind of a set amount, like a safety bonus. You get $100 this month if you meet the safety requirements. That needs to be divided just by the straight time hours only, pursuant to a court case out in California a couple of years ago. Now let's talk just about some general rules of the regular rate. So it's all compensation that someone earns. And this is where sometimes there's a question, what needs to go in and what doesn't go in, and we'll talk about kind of what compensation is included and what's excluded. But if someone earns a commission or a shift differential or something like that, that is going to increase the rate of pay, and it might change each week. So it's not always going to be, the regular rate is not always going to be the same rate each week. It might be higher than the employee's hourly rate. It's something that you are going to have to calculate on a week-by-week basis. And if you're going to calculate that regular rate on a different basis, if you're going to calculate it on the pay period basis, so if someone's paid bi-monthly or semi-monthly, that could result in underpayments or overpayments, just depending on how those calculations are conducted. So it really does need to be done week to week, even if you're paying on a different cadence, which a lot of people do. They pay either bi-monthly, semi-monthly, or monthly. But you still have to break it down so that you're looking at compensation week to week. And so it's that regular rate, not the hourly rate, that's multiplied by 1.5 to obtain the overtime rate. And those are just kind of the key concepts of what that regular rate means when we're talking about regular rate. So what compensation must be included and what can you exclude? Compensation that must be included, so kind of at the base, it's your hourly wages and your salary, okay? So if you're, and we're just talking here, and I want to back up a little bit. When we're talking regular rate concepts and when we're talking overtime concepts, we're talking just overtime eligible employees. So these are either your hourly or your salaried overtime eligible employees. We're not talking exempt employees. You don't have to worry about calculating regular rate for exempt employees because they're not subject to overtime. This is really just to get the rate of pay for your exempt, for your non-exempt employees and figuring out that overtime rate that they need to be paid. So what compensation must be included and what can be excluded? Hourly wages, salary, commissions have to be included, non-discretionary bonuses, and we're going to talk a little bit more about what's non-discretionary and what's discretionary. Prizes and awards that are related to work, and this can be both monetary and non-monetary prizes and awards if they're related to work, and we're going to talk a little bit more about that. Shift or job differentials. So if you pay $2 extra for working a night shift, or if you pay a premium for working a certain job, that all needs to be included. And on-call pay. So if you're going to pay someone say $100 stipend for being on call for the week, that compensation goes into the overall calculation for looking at and determining the regular rate. Now, what you can exclude is you can exclude employee benefits. You don't have to include payments for time not worked. Actual business expense reimbursement. So if you're going to reimburse someone for business expenses, you don't have to include that. We'll talk about the premium pay. There are certain statutory exclusions, and they're very specific. So you have to make sure when we're talking premium pay exclusions that you're meeting the statutory definitions. But there's certain very specific exclusions that you can that can be excluded. Then there's a category of gifts and special occasion bonuses or special occasion payments that can be excluded, and we'll talk a little bit more about that. And discretionary bonuses, which is always the key topic. So getting into what can be excluded in terms of employee benefits. So the things that we typically think of as employee benefits that don't have to be included, of course, would be things like payments that you receive for retirement, benefits, or your health insurance benefits, disabilities, things of that nature. There is something. It does have to be a bona fide plan. It does have to be paid to make. They do have to be contributions made either to a trustee or a third party in order to be excluded. And so the one thing that I do see sometimes under this category that cannot be excluded is cash in lieu of benefits. So I will just kind of note that if you're going to pay someone who doesn't, say, use your health plan or your, other benefit plans, if you're going to pay them an amount that's cash in lieu of benefits and it's a cash payment, that likely will have to be included in the regular rate. There are certain profit sharing or savings plans or stock options, so long as they comply with the regulations. And I get a lot of questions about restricted stock units, so the RSU plans. There has been a lot of back and forth on those, and there have been proposals out there to the Department of Labor, to Congress, to further define how to exclude those. But if you have questions on your RSU options and if those need to be excluded, we could take a look at those. But that is something that you'd want to make sure that it complies with specific regulations about whether or not it can be excluded. And then in December of 2019, there were revisions to the regular rate regulations that clarified that certain benefits, like parking benefits, like parking spaces, but not commuter subsidies, could be excluded. And tuition benefits, if they're, no matter how they're paid, if they're paid to the employee or the student loan program or the education provider, those can be excluded. Other benefits that are provided to all employees, wellness programs. I saw some reference in some of the comments that were made to the Department of Labor for like Weight Watchers memberships or things like that, certain wellness benefits, but gym memberships, fitness classes, things like that, those can be excluded. And then discounts. So there had been some litigation over whether you could provide, whether the cost of a discount to an employee. So say you're passing along an employee discount, if you work, I don't know, for example, for a retailer and you're going to give an employee discount, whether that amount of a discount needs to be included, at least according to the Department of Labor, that can be properly excluded. And I have seen that applied, for example, if you're going to have employees utilize a cafeteria that's located at a work site or something like that, and you're going to offer food at cost or at a discount, or merchandise from a company store at a discount. Likely all of that can be excluded pursuant to these revisions. Other things that can be excluded can be payment for non-work time. So things, vacation, holiday, sick pay, They also don't count towards determining whether an employee has worked more than 40 hours in a week. They don't count as work time, and they also don't count as payments that need to be included in determining the regular rate of pay. One area that we do see questions on, and I've actually seen litigation on, is business expenses. So generally, the payment of business expenses can be excluded. And so this includes, and I understand that there's tax implications, so you're going to have to look at this kind of under like a two-tier analysis. So one are the tax implications, of course, but the other is the regular rate of pay implications. But anything that is a reimbursement of a business expense, so travel expenses, relocation expenses, training expenses, things like that that are kind of a direct reimbursement for expenses incurred that go to the employee, those can be excluded. That's not compensation that they're earning. That's a reimbursement for something that they've expended. The area in which we do see there are challenges in terms of litigation, in terms of liability potentially, and that you just want to keep an eye on is with regards to per diems or allowances. So oftentimes, say an employee is traveling or they're moving or something like that, and you provide a set per diem or an allowance without checking or doing an analysis as to whether or not the per diem or the allowance is large enough or not large enough to cover the expenses that have been incurred. So there's two problems with this. One is if it's not large enough, right, and employees have to pay out of pocket, depending on how much they make, it might cut against minimum wage, right? So you might have a minimum wage violation. The bigger issue, the one that we see more frequently, is that it's not directly related to the actual expenses that they incur, and so there's a delta there, right? So that they're actually pocketing a significant amount of money. And that delta is what then turns into compensation and what really needs to then go back into the regular rate of pay. It's almost like no good deed goes unpunished in a way, but it can be if you're not, kind of closely analyzing or monitoring per diems or allowances, it could lead to a regular rate concern or consideration. I did want to touch on those premium pay exclusions. So, as I mentioned, there are very specific statutory exclusions in terms of certain premiums that are paid by employers that can be excluded from the regular rate of pay. Those kick in very specific circumstances. We've kind of identified them here. One being extra pay for hours worked over 8 in a day or over 40 in a week. There are some that if it is, put into a collective bargaining agreement, potentially under certain circumstances, it could be excluded. So you just have to be very specific. Or if you're sitting down to renegotiate a CBA, you might want to take a look at what those potential exclusions are and see if there's a way that you can take advantage of that, or you might already have it in your CBA. Extra pay that's already paid at 1.5 times or more for work performed on Saturdays, Sundays, holidays, or days of rest. So this comes up oftentimes if you're going to pay someone who's going to work on a holiday time and a half for working on that holiday. You can actually take that amount. You don't have to pay them you don't have to pay them overtime on overtime, basically, is what the provision contemplates. So you can, so long as you're paying them at least time and a half for those hours, you can actually, you can exclude that amount from the regular rate. And when you're looking at the total for the week, you could actually potentially use that as a credit for any overtime that you might use, because kind of going back to that point, you wouldn't have to pay overtime over overtime. Now, it doesn't work there are very specific circumstances, and oftentimes you still would have to pay time and a half for the extra pay under these specific circumstances to take advantage of these exclusions. So in most cases, like a shift differential, if you're going to pay an extra $1 or $2, that's not going to qualify. The on-call pay, as I'd mentioned, that's typically not going to qualify. You're still going to have to include that. And like that extra $2 per hour for working on a Sunday, that would be, like a shift differential that would not be at time and a half. That's just a little bit extra. And so that wouldn't fit neatly or squarely within the statutory exclusion. And so you would still have to include that extra $2 an hour in calculating the regular rate. Let's talk just briefly about gifts. So gifts comes up a lot. Gifts are really payments or items. It could be monetary or non-monetary. It could be, a turkey at Thanksgiving that's given to everyone. It could be a gift that is given at the holidays to everyone, or a special occasion, retirement gifts, or certain achievement gifts, 15 years, 30 years, you get either an amount of money, you might get a gold watch, something like that. It really needs to be given to everyone, right? Shouldn't be dependent on hours worked, shouldn't be tied to production or efficiency, and it shouldn't be so big that an employee considers it payment as part of wages. So you shouldn't have like a $2,000 bonus to everyone at the holidays is probably a payment that's so large that people are relying on that as part of their wages, maybe relying on that to buy holiday gifts or to take a vacation at the end of the year or something like that. That might trigger an amount that would need to be put into the regular rate. Okay, so let's talk about discretionary bonuses for a second. Now, discretionary bonuses and this is probably the one I get all the time. Well, it's discretionary, so I don't have to include it. Discretionary really means it's discretionary as to both the fact and the amount of payment. Now, I often hear that, say, an annual bonus is discretionary because it's within the company's discretion whether or not to pay anything, or maybe it's dependent on the company's overall performance. This typically does not make it discretionary because it just goes to the amount of the payment, not the fact that bonuses are considered in the first place. So if there is a bonus program or a bonus potential at all, whether or not the potential for a bonus payment is zero or, insert amount, that means that bonus is likely non-discretionary. Really, a truly discretionary bonus is, I walk up to Michael. Michael, you did a great job on this presentation today. Here's $100. And he has no expectation of that. It's nothing that has been announced or designed or tied to any expectation of receipt of payment. It is just a spot bonus. And that's really, one of the true or few examples of a discretionary bonus. Now, as I'd mentioned, bonuses typically have to be included, and so do prizes and awards, even if they're non-monetary. Okay? So this can be all bonuses that are tied to productivity, tied to work-related, like retention or safety bonuses, as well as prizes or awards, such as those given for meeting production or sales goals. now you can exclude, as we talked about, and this kind of goes back to gifts, but it also goes into kind of special occasion awards. You can exclude certain special occasion awards or bonuses, like that gold watch given for 30 years of service, or a prize for the best Halloween costume that's given to anyone. Or a recruitment bonus, because that's given to anyone unless it's given to someone whose job is to recruit, or there is a retention requirement required to earn. So like you have to be there for 90 days and the person you've recruited has to be there for 90 days. All right, so let's do a quick example just so we can illustrate what we're talking about when we're talking about the regular rate. So let's say Jill earns $20 an hour working on the production line in a manufacturing plant. She works 45 hours. She also earns $2 an hour for 5 hours when she worked the third shift. So she has a shift differential. And she exceeded her production goals for the week, so she earned an extra $50 bonus. So here's how you would calculate, because she has a lot of additional compensation that week. So here's how you would calculate her regular rate for the week. Her straight time would be the 45 hours at the $20 an hour for the straight time. So she earns $900 in straight time. But then to that, we have to add this $10 shift differential and the $50 bonus. So her regular rate is the $960 of total compensation she received divided by her total hours of 45. So now we've gotten to her regular rate of pay is $21.33, and we multiply that by 0.5. And so why do we do that? Because we've already done the 1.0 calculation. We've already done multiplied this by all the hours she's worked. So we just have to get the halftime premium. And then we multiply that by the number of overtime hours she's worked, and we get to the overtime premium, and we add that all together. So we get the $960 that was her regular rate plus the overtime premium, and that's how we get to her regular rate for the week. Now, there are some times when you have compensation that's paid monthly, quarterly, or annually, and so there are different formulas that you can use for that. So and you can really use this in any circumstance, but you would take the total amount divided by the total hours in the period times the 0.5 times the overtime in the period to get that additional amount. So we're providing you with kind of that formula. And I will just note that, again, that flat sum bonus formula does change that a little bit, because you're going to have to multiply that by 1.5.
Wow, Libby, there's certainly a lot to unpack there. Thank you so much for walking us through all that. Ladies and gentlemen, what a great turnout. We had over 1,700 people participate, so thank you so much. If you look in the right corner of your presentation screen, you should see that link where you can work with us to get a demonstration and free trial. If that doesn't work, try demo@compliance.hr, or feel free to ask us in the Q&A box. We have saved our clients millions of dollars in potential legal fees and non-compliance lawsuits by using AI tools to help them run their businesses. We provide the most accurate information before the laws take effect, so you can be proactive when you approach the different challenges that you come across day in and day out. And please remember, if you're not using AI to run your businesses, you are at a significant disadvantage. All right, Libby, we have a few minutes left for a couple of calls or a couple of questions. We had a zillion come in. One that kind of stuck out that I liked, when classifying an employee in the state that has a different exemption than federal law, do you essentially ignore the federal level? Is that if there is a conflict?
That's a great question. Depends on what the requirements are. So sometimes they work sometimes they work together. So sometimes there is like in California, I would say yes. You're really going to be looking at the California requirements, because in almost every category from duties to compensation level, there's a difference. In other states, some states still have the same compensation level, but they might change the duties slightly, and so you might have to take them in conjunction with one another. In that you might have to look at the duties separately, and you would always err towards the duties that are, I was going to say, usually the states have the most generous duties, or they have duties that are greater than, or provide more restrictions potentially in terms of percentages or something like that than the federal duties if they have additional duties. And so yes, you would always have to make sure that you're following those requirements as well.
Excellent. Thank you. We are at the top of the hour. I was going to answer one simple little question that came in, and someone asked, does compliance HR contain information on state and local labor laws? Yes, we provide federal, we provide state, and we go right down to the jurisdictions when appropriate. So I want to thank everyone for their time today. Libby, wonderful to work with you again and sharing your great information on overtime. If you have any questions, folks, please reach back out to us. If you're serious about dealing with these compliance challenges with overtime, schedule some time with me and my team at demo@compliancehr.com. Again, thank you everyone for your time. Libby, thank you, and please enjoy the rest of your day. Thank you so much.
Thanks, Al.